Last Friday, on June 24th, the United States Supreme Court voted to strike down the landmark Roe v. Wade and Planned Parenthood v. Casey decision, effectively ending recognition of the constitutional right to privacy that protects a woman's choice to have an abortion, and giving individual states the power to allow, limit, or ban the practice of abortion altogether. This ruling represents a significant rollback of women's rights and profoundly undermines a basic human right to bodily autonomy. This comes as no surprise to many, since there are leaks of this decision since May. However, there are still facts about the decision people are unaware of. So let's look at how this decision came to be to fully understand our current situation. Roe v. Wade is a 1970 lawsuit in which a woman under the fictional name Jane Roe filed a lawsuit against Henry Wade, a Texas district attorney, challenging a Texas law making abortion illegal except by a doctor's orders to save a woman's life. In her lawsuit, Roe alleged that the state laws were unconstitutionally vague and reduced her right of privacy protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. In the defense of their abortion statute, Texas made three main arguments. One is that states have an interest in safeguarding health, maintaining medical standards, and protecting prenatal life. Two, a fetus is a person protected by the 14th Amendment. And three, protecting prenatal life from the time of conception is a compelling state interest. On the other side, Roe and others involved argued that the Texas law invaded an individual's right to liberty under the 14th Amendment and infringed on the rights to marital, familial, and sexual privacy guaranteed by the Bill of Rights, and that the right to an abortion is absolute because a person is entitled to end a pregnancy at any time for any reason and any way they choose. Ultimately, the Supreme Court decided that the Due Process Clause of the 14th Amendment protects against state action on the right to privacy, and that a woman's right to choose to have an abortion falls within that right to privacy. But there's a catch to all of this. The decision didn't exactly legalize abortion, and the Due Process Clause doesn't explicitly state that Americans have a right to privacy. It just so happened that the Supreme Court had recognized such a right going all the way back to 1891. And just 1 year before Roe, the Supreme Court held that in a constitution for a free people, there could be no doubt that the meaning of liberty must be broad indeed. So, in the Roe v. Wade decision, the court decided that the right to privacy extends to control over pregnancy, and acknowledged that being forced to continue a pregnancy puts a person's physical, mental, financial, and social health at risk, while not agreeing that the Constitution guarantees an absolute right to an abortion, and that the privacy right does not prevent states from putting some regulations during the third trimester of a pregnancy that may prohibit abortions unless it's necessary to save the life or health of the pregnant person. Unfortunately, that gray area left room for states to challenge abortion, and Mississippi did just that in 2018 when they passed a law that banned abortions after 15 weeks of pregnancy. Lower courts have prevented enforcement of the law in the case of Dobbs versus Jackson Women's Health Organization, with preliminary injunctions based on the ruling in the Planned Parenthood versus Casey case, which had prevented states from banning abortion within the first 24 weeks. However, with the ideological shift of the Supreme Court that culminated with the 2020 appointment of Justice Amy Coney Barrett, who was outspoken against abortion, made the Dobbs case a vehicle to challenge both Roe and Casey. Eventually, when the case came to decision in the Supreme Court, a 6-3 ruling was given to reverse the lower court's rulings. Then a 5-4 ruling was given to overturn Roe and Casey. The majority opinion stated that abortion was not a constitutional right, and that states should have discretion in regulating abortion. This Supreme Court decision shows that 1, they don't care about the right to privacy that protects a person's choice to have an abortion, and 2, the whole thing about being pro-life is all a facade, because if they really care about being pro-life, they would have fought more for paid maternity leave, affordable health care, and mental resources for mothers. And let's not forget about the lives they're claiming to be protected, because they clearly don't care about them once they are born. Unfortunately, kids that are born in disadvantaged situations are the ones who have learning disabilities, history of poverty, neglect, or abuse, and are criminalized, isolated, and set up to fail by the public school, foster care, juvenile, and criminal justice systems. But pro-lifers have given no focus on caring and protecting them from these systems, even though there's arguments showing that more funding and resources could help reduce kids being lost in the system. This hypocrisy is so disgusting, but this is all by design. I see the problems, but can't really do anything about it because we the people are blinded from the fact that we're not in control, but are pawns in a country whose politics is controlled by big corporations and the wealthy elite. So with that being said, the Supreme Court is setting up the stage to revoke other landmark cases like contraception rights to push the population control agenda, while we continue fighting and arguing, not seeing that our division is giving them more power to do whatever they want.